Hello and welcome to the lesson on the role of the Supreme Court under the Constitution in the protection of the human rights. Friends, to start with, the Constitution of India embodies special provision for protection of human rights. In carrying out a study in this aspect, it is pertinent to ascertain the definition of human rights, to appreciate the mechanism adopted by the Constitution to enforce such rights, the inclination of the court to enforce the rights created by the international law, and the law of compensation as a public law remedy for violation of the rights to life. In the first place, the Constitution of India declares a list of fundamental rights guaranteed under Part 3. Thereafter, among those rights, the most important one is right to enforce any of those rights is also guaranteed under Article 32. The Supreme Court is empowered to issue directions, orders or writs in the nature of habeas corpus, mandamus, quo warranto, certiorari, and prohibition for the enforcement of those rights. The fundamental rights occupy a place of pride in the Indian Constitution. Article 21 provides, no person shall be deprived of his life and personal liberty except according to the procedure established by law. Personal liberty is a sacred and cherished right under the Constitution. The expression right and personal liberty include right to live with human dignity and a comfortable life, not merely an animal existence. As far as the human rights is concerned, since the 17th century, if not earlier, that a human thinking cropped up and roving around a theory that man has certain basic and inviolable rights, and it is for the state to protect those rights. There existed the age-old maxim, ubi jus, ibi remedium, which meant that there is no right without a remedy, meaning thereby, in every case a man is wrong, he must have a remedy to maintain it. A mere declaration of a bundle of the rights does not by itself provide a meaning of human right unless there exists some mechanism to enforce it. The Universal Declaration of Human Rights is adopted and proclaimed by the General Assembly of the United Nations on the 10th of December 1948. And this is an international charter of the human rights which contains 30 articles. Article 8 lays down that everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted to him by Constitution or by law. As regards the Constitution of India, after listing the fundamental rights, in its Part 3, Article 32 lays down the right to move the Supreme Court for enforcement of any of the rights conferred by the part which is guaranteed. Article 32 itself is a fundamental right, but the Constitution does not define the term human rights, even though it declares a list of rights called the fundamental right. The term human right is also not defined in the Universal Declaration of Human Rights. The term human rights is defined in the law known as the Protection of Human Rights Act 1993. Section 2, subsection 1, clause D of the Act defines the term human rights. It has been defined that human rights means the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by the court in India. International covenants is further defined to be the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights adopted by the General Assembly of the United Nations on the 16 December 1966, and also such other covenant adopted by the General Assembly of the United Nations as the central government may by notification specify. So we discuss now enforcement of the human right, the constitutional provision. The human rights are guaranteed by the Constitution not only against the state action relating to executive but also against the legislature. Any act of the executive or legislature which takes away or abridges any of the rights conferred by Part 3 shall be void, and the courts are empowered to declare such acts to be void. This is laid down in Article 13 of the Constitution. The main object of Article 13 is to secure the paramountcy of the Constitution in regard to fundamental rights. Apart from having the power to declare a law to be void as being in contravention of the provision of the constitutional guarantee of the fundamental rights, the Supreme Court is armed with the power to enforce such rights against any authority in the state at the instance of an individual whose right has been infringed. Article 32 itself being fundamental rights, this remedy is immune from being overridden by any legislation. Any law which abridges the Supreme Court's power to grant this remedy shall be void. This is illustrated by the Supreme Court as early as in the year 1950 when it decided the case A.K. Gopalan versus State of Madras. 1950 Supreme Court report, page number 88. In that case, the Supreme Court invalidated Section 14 of the Preventive Detention Act 1950. The provision was struck down on the ground that it contravened Article 32 by way of preventing the Supreme Court from effectively exercising the powers under Article 32. As far as the limitations upon the enforcement of the fundamental rights are concerned, in the first place, the Parliament shall have the power to modify the application of the fundamental rights to the members of the armed forces or police forces so as to ensure proper discharge of their duties and maintenance of discipline among them. Secondly, when martial law has been enforced in any area, the Parliament may by law indemnify any person in the service of the Union or of a state in respect of any act done by him in connection with the maintenance or restoration of the order in such area, or validate any sentence passed or act done while martial law was in force. This is provided in Article 34. The fundamental rights guaranteed by the Constitution under Article 19, that is 6 freedoms of the citizens, is automatically suspended while a proclamation of emergency under Article 352 is in operation. This means that the legislature shall be competent to make law, and the executive shall be at liberty to take any action even though it contravenes or restricts the fundamental right of freedom of speech and expression, assembly, association, movement, residence, profession or occupation. So far as these rights are concerned, the citizen shall have no protection against the executive or legislative authorities during the operation of the proclamation of emergency. Article 19 will revive as soon as the proclamation expires, but the citizen shall have no remedy for acts done against him during period of proclamation in violation of the above freedoms. The other consequences is the President may by order suspend the right to move the court for the enforcement of any of the fundamental rights except Articles 20 and 21 that may be indicated in the order. If such an order is issued, the Supreme Court will be powerless to issue the writs or to make any other order for the enforcement of any other fundamental rights that are indicated in the presidential order, including Article 19. Enforcement of international law is another aspect. The rights declared under any international law do not automatically become an enforceable right in India unless such a rule of international law is embodied in any law made by the Parliament. However, under Article 51 of the Constitution, the state shall endeavour to promote international peace and security, maintain just and honourable relations between nations, foster respect for international law and treaty obligations in the dealings of organized peoples with one another, and encourage settlement of international dispute by arbitration. The Supreme Court felt that it is under an obligation to see that message of the international instrument, it is not allowed to be flouted. The court has in numerous cases emphasized that while discussing constitutional requirements, the court and the council never forget to core principle embodied in the international covenants and instruments, and as far as possible give effect to the principles contained in those international instruments. Export Promotion Council versus A.K. Chopra, reported in AIR 1999, Supreme Court 625. The Supreme Court observed that the courts are under an obligation to give effect and due regard to the international covenants and norms for construing domestic laws, more so when there is no inconsistency between them and there is a void in the domestic law. In Bodhisattva versus M.S. Durba Chakraborty, AIR 1996, Supreme Court 922, the Supreme Court was influenced by the ILO Manila seminar held in 1993, and the judicial thinking became loud that rape is a crime against the basic human rights. In the Municipal Corporation of Delhi versus Female Workers, AIR 2000, Supreme Court 1274, the Supreme Court extended the benefits of the Maternity Benefit Act 1961 to the muster roll daily wages of Delhi Municipal Corporation. In this case, the court directly incorporated the provision of Article 11 of CEDAW 1979 into Indian law. These are some of the examples. that the Supreme Court has been greatly influenced by international human rights instrument in extending the horizon of the human rights of the people. As regards the law of compensation, the emergence of compensatory jurisprudence for violation of right to personal liberty took place in the case Rudul Shah versus State of Bihar, AIR 1983, Supreme Court 1086. In that case, monetary compensation was granted to an unfortunate victim of state lawlessness on the part of the Bihar government for keeping him in illegal detention over 14 years after his acquittal of a murder charge. After Rudul Shah, the Supreme Court entertained many cases of granting compensation in its exercise of the power under Article 32. To mention some of the cases are Sebastian M. Hongre versus Union of India, AIR 1984, Supreme Court 1086. Bhim Singh MLA versus State of Jammu and Kashmir, AIR 1986, Supreme Court 494. Saheli versus Commissioner of Police Delhi, AIR 1990, Supreme Court 513. Nilavati Behra versus State of Orissa, AIR 1993, Supreme Court 1960. The Supreme Court in Nilavati Behra observed that award of compensation in a proceeding under Article 32 is a remedy available in public law based on strict liability for contravention of fundamental rights, to which the principle of sovereign immunity does not apply. Thus, the role of the Supreme Court is significant in this innovative creations of public law remedy of compensation in exercise of its power under Article 32, as a matter of which is incidental to the enforcement of guaranteed fundamental rights under the Constitution. In order to conclude, the role of the Supreme Court in the protection of the human rights is significant. Judicial activism is seen to be prominent. The court's power, even during emergency, will be significant, as Article 20 and 21 are made beyond the power of the President to suspend by an order. The international law perspective is another dimension. A practice has been developed to incorporate international law into domestic law and made the horizon of the human rights wider and wider. Over and above all the developments of the law of compensation as a public law remedy is welcoming practice. The Supreme Court plays a very important role in the growth and development of human rights.